And so most people want to avoid probate as much as you can. If you've heard bad stories about probate, it's probably true because it is a pretty bad process in general. But I'm happy to answer questions along the way. And there's a lot of things about estate planning that, again, people just get wrong. And so my goal is to be here to dispel any myths and answer any questions about any confusion that comes up.
Perfect. Thank you, Justin. I will also add, as a side note, that Justin and I have known each other since we were, I think, 5. We played t-ball together here in San Diego and have been very good friends ever since. Our dads coached our t-ball team together back in
Very
the
fortunate
late
that we
80s.
went into adjacent fields that kind of work
Yeah.
together. So didn't plan it, but it all worked out very nicely.
All right, so here's the agenda. First, let's talk about basics of estate planning, and then I'm going to jump into common mistakes. And then after that, we will talk a little bit about what to do after you've created your trust, which I think is kind of underappreciated. I think that'll be I really want to kind of hammer on that because you're not done once you create a trust. And then we'll open up to questions. So, first off, estate planning basics. There's a difference between a trust and an estate plan. And Justin, can you talk a little bit about how, an estate plan doesn't necessarily protect you if you're in the state of California versus how a trust protects you in the state of California?
You mean like a will, more specific?
Precisely. Yeah.
Yeah, so ultimately the goal is to avoid probate. Now, a will still allows you to have some say in what happens to your estate, but ultimately it still goes through the probate court. And when you have a trust, you don't have to worry about the probate court because it's all done outside of probate. There are so many bad things about probate, it would take me forever to explain them all. But the basics are it takes a very long time, it's very expensive, it's very public and accessible for people to be a part of, which we obviously don't want. And it's very it's a lot of red tape. It's very prohibitive. And it's just a bad process in general. So I often tell people, when they say like, "Oh, what's the probate process like?" I tell them it's like going to the DMV for 2 years straight. So if you like going to the DMV, you're gonna love going to probate.
Yeah. Yeah, I equate that with other financial planning issues. The DMV seems to be a good analogy for a lot of different things that you can avoid if you set your stuff up correctly.
Mhm.
Okay. Let's so being that a trust protects you, something that I think kind of dives a little bit into what we'll talk about at the end is mistakes, but what happens if you have something that's you own an asset, for example, or maybe it's a bank account.
Mhm.
You've created your trust, but that particular asset is not in the trust, or it's not registered in the name of the trust. Can you still avoid probate in that type of scenario?
Yeah, technically, and ultimately, when it comes to putting an asset or making an asset covered by your trust, is when you are funding your trust. So, a properly funded trust means your assets are controlled by the trust or covered by the trust. There are certain things that you probably don't want to have go through your trust. And I'm sure Joe would advise this as well, but it would be more of your retirement accounts, 401ks, and IRAs. It is more ideal to have that go to a human than it would be to go through the trust. Now, if you do want it to go to somebody who is a minor, let's say, you want it to go to your trust because the trust would then control it and make sure your trust has the proper language that allows for control of those retirement accounts or assets like that. So you'll need to make sure that language is in there in order for it to be, controllable. But generally speaking, if you're a married couple, you'll have your retirement account go to your spouse and then maybe like your kids or beneficiaries, and your trust can be a last option there, but it's not necessarily ideal for it to be a first or second option. But it's still better than probate, so that's why
Okay.
I would say as a contingency you can always put your trust there. But checking accounts, savings accounts, stocks, bonds, mutual funds, brokerage accounts, you should have either your trust be the owner or the trust should be the beneficiary. Either way is still okay because it allows for access upon passing. Think of your trust as the mechanism for your family, your kids, your loved ones to access your accounts if you passed away. If you have a bank account with $50,000 in it and you have no beneficiary, you don't have the trust mentioned, well, your successors have to do extra work in order to get access to that upon your
Okay.
passing. And that's what we're trying to avoid.
Okay, so it's extra paperwork basically is probably one of the major downsides if you have a bank account, but the trust is not either the owner or the beneficiary.
Yeah, I mean,
Can you,
depending on the value, if it's more than 200,000, which is the probate threshold, that means we have to go to the court in order to handle
oh
that,
wow.
which is what we want to avoid. Now, there's ways to do that as an estate planner. I can get access to it, usually within probably 5 months as opposed to 2 years because we have
Jeez.
these tricks that we can, use case law and things like that. But at the same time, we just don't want to have to go through that process because that just means more money to get access to these things as opposed to just getting immediate access because your name or the trust name is on the account or the trust is the beneficiary.
Okay. So that just is not unlike probate, you can somehow get access to it, but it's 5 months as opposed to 2 years. Plus, I mean, that still costs money, maybe not as expensive as probate, but it's still going to be, attorney fees involved with being able to access, I would
Oh,
imagine.
absolutely.
Yeah.
So okay. So here's a good example. People will do a refi on their house, not right now because rates are terrible, but when rates are really good, people were doing a refi all the time. And a lot of times these refinance companies will ask you to take your property out of the trust and so they can fund the loan. And then the goal, the idea is to put it back into the trust, your property. A lot of times they forget to do that. And so we would have tons of people passing away with their properties outside of the trust, but it was supposed to be in the trust.
Hmm.
And so what we do is essentially we go to the courts and we use what's called a Hegstead petition. So it's basically just a using case law from the 1990s that tells the court, look, they meant to have this in their trust, but they didn't. So let's get it transferred to the trust posthumously. And this happens all the time, and we do these all the time. But it costs money, it takes time. We don't want to have to do that. We want to be able to have access immediately, and that's why you have the trust in the first place.
Okay, so if that happens, well, let me back up. How does somebody make sure that their house is in their trust?
If you have the deed, you should know. You can
Okay.
usually call the county, or you can email me, and I'll double check because we have access to title, so I'll be able to find out what's the most recent deed that was recorded on your property. So it's important to know, like, if you've done some refis and done some things over the years, it's good to know that your house is in your trust, and also that it's funded, titled properly,
Yeah.
because we've had so many times where people have mistitled a deed where it's supposed to be like John Smith as trustee of the John Smith Trust and the date, but they'll have like one letter missing or the date
Jeez.
isn't listed on there or the trustee's not listed on there, which is just a huge headache for your successors later on. You want to make sure it's titled correctly. Otherwise, it's just more
Okay.
work, more headache.
All right. Got it. All right. I'm going to move on. We're going to dive a little bit deeper into trust, but the components to a trust, which you'll see more on the next slide, but is primarily your advanced care directives, your power of attorney, your will. Those are some of the main components to it. Now, you can have an estate plan that has these components, I guess, out, not necessarily inside of the Joseph Stenovec trust, right? I
Yeah,
can have just a POA document.
Yeah, I would refer to the all these documents together as the estate plan.
Okay.
So you'll have your trust, you'll have your power of attorney for finance, you have your power of attorney for health, also known as an advance directive. There's a lot of different terms that you might see for these things, but the will is not the type of will that we were just bashing a second ago. The will is
Yeah.
actually a pretty important thing. It's called a pour over will, like you're pouring water into a glass.
Hmm.
It is a safety net. That's all it is. It just says, I give everything I have to my trust. And that way, if you have something outside of your trust, like this property or a bank account or whatever it might be that was supposed to be titled to your trust, but it wasn't for whatever reason, this is your default mechanism, our backup plan that says, hey, put it all into my trust. That's what the default is.
Got it. Okay. All right. So let's talk a little bit more about two things specific to a trust, the durable power of attorney and the advanced care directive.
Hmm.
So within your trust, you have a successor trustee,
Hmm.
somebody that's going to basically execute on your wishes that are, determined by your will. And you also have a power of attorney and advanced care directive. So can you talk a little bit about power of attorney, and I'll add a little bit of color on the financial planning side, but what's the point of POA and advanced care directives?
Yeah, let me take one quick step back. You said a second ago that's controlled by your will. Remember, your will, we don't want to do anything. Your will
Right.
is
Yeah,
just a
sorry.
supplement to the trust. So
Yeah.
the more common term that you'll hear is executor. Executor and successor trustee, those are the same thing. That's just who is going to administer your trust when you pass
Hmm.
away. So your trustee, someone you trust, to make sure they're going to fulfill your wishes and administrate your trust according to the terms of your trust. So that's a really important job and responsibility for somebody to have. That way, you don't want to choose anyone who is not great with, I guess, getting things done. No procrastination. Not someone who's not good with money. You want to have a responsible person in that role. But the power of attorney is separate, and your power of attorney is going to control non-trust assets. Your trust will control trust assets. So in a scenario where I have a house and a bank account and a 401k. Very straightforward, very, easy to administer. If I become incapacitated, my house and my bank account should be under my trust, and the trust controls that. If I become incapacitated, my power of attorney will control the 401k. So they have different roles and responsibilities, but usually your trust controls trust assets, your power of attorney controls non-trust assets.
Okay. I guess if your bank account,
Mhm.
an example of maybe the POA stepping in would be, let's just say you go to your bank and you're like, hey, I completed my trust. I want to move my checking and savings account into my trust. And the
Mhm.
bank is like, well, okay, that sounds great. That's considered a new entity. You need to open a new bank account and a new savings account.
Yeah.
And you're like, well, that just seems like a complete nightmare. All the direct bill, credit card, I
Yeah.
mean, everything like that. So say
There's
you
ways
name
around
the
it.
beneficiary,
Yeah.
the trust's beneficiary. Technically, the trust doesn't own the bank account in that example, but that's an example of where the POA could step in and take.
Exactly.
Okay.
Yeah, so you'll have two different ways to title a bank account. Chase is the worst, the absolute worst. It's not even close when it comes to estate documents or trusts and whatnot, because they're going to ask you to close down your accounts and start brand new ones. And other big banks are not great as well too. But mainly, your goal is to either have your trust be the owner of the account or the trust is the beneficiary of the account. So if I pass away, then my successor trustee can get access to my bank account through my trust. If I pass away and the bank account has the trust as the beneficiary, then the trust just gets a check written out to it for the contents of my account. Either way, it's going towards the trust. That's the goal. Whether
Okay.
upon incapacity, I either my trust is used or the power of attorney is used, really just depends on the situation and how you have your account titled. But either way, we want some mention of the trust either as owner or beneficiary.
Okay. Um, let's talk a little bit about the next slide is about wills, which we're kind of already talking about, but I want to kind of peel back the onion a little bit more on beneficiary structure
Hmm.
and retirement accounts because for a lot of people, one of their biggest assets, retirement assets, is their 401k or their IRA outside of their house.
Hmm.
House, for the most part, if you have a trust and your estate planning attorney is doing doing the right thing, like they're gonna record it, right? So if you create a trust with Lawyer and Blue Jeans, then you're gonna do that recording on their behalf and move
Correct.
retire the house. Okay. So with retirement accounts, you don't necessarily need to name the trust as the beneficiary. There are situations where it may make sense to name the trust as beneficiary. And this conversation, I think this is relevant for some of you on this webinar for your kids, because some of you on here I know have kids and you have grandkids. Um, but and for some of you, the beneficiary is your grandchildren. So when does it make sense, in your opinion, I'll add some color too, when does it make sense to have the trust be the primary beneficiary of a retirement asset, retirement account?
I'd say if you want that retirement account to be funded in a certain way in your trust or to go to somebody who is not trustworthy with money and you want to have some semblance of control. So, say
Okay.
you want your 401k to go to your daughter and your daughter's not great with money or is having a problem with drugs or alcohol, we want to be able to control that money just doesn't get blown and and squandered right away. So you might put it into your trust as the beneficiary, and then within the trust, it will say, okay, this specific 401k account or all of the funds dedicated going to your daughter go into a sub trust or a structured trust where she receives, $1,000 per month indefinitely, or maybe a percentage each year. It really just depends on what you want because it's very customizable. But that would be the
Okay.
only time that I would say that a 401k or an IRA, even an annuity, would go through a trust would be for your, I guess, desire for control beyond your normal controls, I guess.
Okay. All right, that's helpful. I have seen some clients that have like old annuities,
Hmm.
non-qualified annuities, and the trust is the beneficiary or the trust owns the annuity.
Hmm.
And that can become a tax nightmare when you pass away. Because if you have an annuity, let's say you invested $100,000 into an annuity some years ago, and the value of that annuity is increased to $300,000, and you
Hmm.
pass away, if the trust owns it, there's a more than likely your beneficiaries are going to be subject to the 5-year rule on that annuity, because most annuities require, when it's owned by the entity like that, require distributions to be completed within 5 years. And you don't have the ability, when this trust owns it, to stretch it over the beneficiary's life expectancy. So I have seen that happen with some a couple clients in the past, some years ago, where they had this old annuity, and they're like, they came to me and they're like, what can we do about it? Sorry, there's nothing that you can do. You're inheriting that. Your mom or your dad or whoever it was own that in their trust. You have to distribute that over the 5 years. Done and done. And it becomes a tax nightmare, because if it's the way annuities are structured from a tax perspective, it's all tax deferred, et cetera. So
Yeah.
so if you have an old annuity, make sure it's either not owned by the trust, don't have beneficiaries listed as a trust, none of that. Another good one that I've seen is, if you are charitably inclined, let's say your trust, because another thing you can do is when you're distributing your assets or your wishes at death, a lot of people want to be charitable, and they
Mhm.
maybe want some money to go to charity. So say, for example, your trust states that $100,000 goes to the Humane Society, for example. Um, so that happens, and then the beneficiaries split whatever's left after the charitable distribution occurs. Something to consider is maybe naming those charities as beneficiaries of retirement accounts, as opposed to naming them the beneficiary inside of your trust, because of a couple factors. Not to go off too far from the slides, but it's more tax advantageous for you or for your beneficiaries if a charity or a 501(c)(3) inherits a tax deferred account like an IRA, because they're a nonprofit,
Mhm.
501(c)(3), tax free. Um, and you compare that to a benefit, like say your kids or your beneficiaries on your IRAs. The rules changed dramatically a few years ago with IRAs and non-spouse inheriting it. It used to be that you can stretch that IRA over the beneficiary's lifetime. This changed in 2019, right at the end of the year, and it was right before COVID. And so financial planners were like, "Oh my gosh, they changed these rules," and then 2 months later, boom, COVID hit. But what happened is the IRS is like, "Hey, we don't want this next generation, millennials or whoever, to be inheriting these giant 401(k)s or retirement accounts and being able to stretch out distributions over their lifetime, because those distributions are really small when you're young, and as you get older, distributions they get a lot larger." And so what the IRS said is, you can no longer stretch inherited IRA distributions over your life expectancy. You must distribute these assets within 10 years. And so if let's just say my dad passes away, my mom passes away, I inherit an IRA from them, I have to take out those distributions within 10 years. So yes, I mean, I know I'm inheriting an asset. It's great. But from a tax perspective, if you'd say it's $1 million IRA, 40% of that is going to go to federal taxes and state income taxes. And so because you have to take this out over 10 years, and the IRS clarified some rules around that, but that has to be depleted within 10 years following the year after the IRA owner passed away. So from a planning perspective, two things to consider. Number one, charity as the beneficiary, if that is a part of your estate plan. Number two, Roth conversions during your lifetime, because Roth conversions, basically what that means is that you're going to pay the tax at the time of conversion. In essence, what you're doing is you're taking your pre-tax IRA and you are moving it to a Roth IRA. So you are paying the tax at the time of the conversion. And then it's forever tax-free from there. And the benefit is from an estate planning perspective, is that the beneficiary, say it's your kids, legacy planning and whatnot, there's no 10-year rule on Roth, or there's no tax, I should say, on inheriting Roth accounts. It's tax-free. It's a tax-free asset because you paid the tax at the time of conversion. So just two planning ideas, because for some folks, they have their IRAs are large today, right? And if we fast forward 25, 30 years, if that doubles a couple times between now and then, your beneficiaries are inheriting a sizable asset. But after you factor in the taxes, and who knows what tax rates are going to be at that point in the future. So I just wanted to add that. I don't know if you want to add anything else to that, Justin.
No, I think you hit the nail on the head.
All right. Anything else you want to add on wills? I think we covered it.
Yeah, I just think that, wills are very antiquated. They don't do what you want them to do anymore. And it is still part of the vernacular as, a very common thing to talk about when it comes to TV shows and movies. I got to update my will and whatnot. But ultimately, if you are living in California more specifically, you definitely don't want a will just because of the red tape and the bureaucracy that you have to go through.
Okay. Do you have any idea, ballpark, if you have $1 million estate? And I know there's some people on here that are not in California, but for my California folks that are on here, any idea how much $1 million estate would cost to go through probate in the state of California?
Yeah, the probate fees are sliding scale based on a percentage of value for your estate, and it's something you can find pretty easily online too.
Okay.
Probate fees just for like the attorney who works on it are 25 grand plus usually, and then there's the fees that go to the probate court itself. So it's not necessarily only about the fees. That is a huge problem. But think about the time and the red tape and the bureaucracy and the lack of control. That is one of the most frustrating parts about the probate court.
Okay. All right, let's talk a little bit more on POA, because I think one thing, and this kind of goes hand in hand with amendments, which we can talk about in a minute as well,
Mhm.
is power of attorneys. If you are, let's say you're 60 now and you created your trust, 20 years ago, or whenever, you haven't made any changes to it. If you named your POA, maybe say your mom or dad was your power of attorney, and maybe your mom and dad is in their 80s now, do you still want them acting as your power of attorney? So that just kind of goes to discussing amendments. But
Yeah, it's a good thing to look at these documents pretty frequently, the power of attorney and healthcare directive more specifically, because essentially what you're doing is giving a third party power over you in one way or another, whether it be financial or medical. And for that reason too, a lot of the banks and the hospitals are a little hesitant to accept an older document or something they consider stale. That's their terms, not ours. And that's why they ask for them to be updated, even if nothing's really changed. They want to see
mm,
newer documents all the time, usually within 3 to 5 years is kind of the norm. But if you have something that's super out of date where your parents are listed there and maybe one isn't able to act anymore, there should be mechanisms within your trust where the next person on down the line, down the hierarchy can be appointed. But things change over years too, so it's really good to keep an eye on these and keep looking at them every 3 to 5 years.
so do you see, what are some tips to, like, should somebody have with their, let's say you have a primary care physician,
Mhm.
should they have a copy of their power of attorney or healthcare directives on file with their primary care physician or with their doctor?
I would say primary care physician for sure. Also, the people that you've listed. And granted, this might change over time too. So maybe you choose your father as your first choice, and then maybe your kids as the backup because they're still kind of young. You can always send a scan of the documents to all the people who are technically involved. Now, there's some downsides to doing this as well too, and I don't really need to get into too much of it, but it could be just too much disclosure makes people a little bit weird sometimes.
Hmm.
But make sure that people know about it as well. So you have this kind of balance that you need to do where I want people to know what I have and what my decisions are, but I don't want to cause any anguish or cause any issues now when I choose, one person over another. So you do have a little bit of a balance there. At minimum, your healthcare directive should be given to your primary care physician. In case of an emergency, they can look to the directive to say, okay, this is who they have as their first choice, and they're kind of going off of that document.
So what happens if your directives are outdated and it is somebody that can't act? And that's who
But
you have listed, or that's your POA is somebody
yeah,
that
so
can't act.
if you have someone who can act, then it usually would default to the next person. I can't say for other people's estate planning documents, but our powers of attorney and healthcare directives always have a backup. And
Okay.
and so, I mean, I think only maybe once or twice where somebody put just one person, and we
Okay.
kind of said like, "Hey, you
Yeah.
really need to have
You're
backups."
the one.
Yeah, yeah. So
Uh,
you
okay.
always want to have a backup.
What about naming multiple? So like I have
Absolutely.
three boys. Should I name all three boys? I mean, don't should I name
Maybe
all
not
three
all
of my
three.
kids as a POA after Lindsay?
I'd say like two people is probably pretty good. We do get a little pushback sometimes from banks when we have multiple successor trustees. But if multiple healthcare agents, I think it's a good idea too because you kind of don't have to rely on just one person. If one's traveling, then hey, someone else can step up. But we also have to balance too many cooks in the kitchen. We don't want too many people getting involved and there to be, infighting and that's really dependent on your family dynamic.
Okay, yeah, you just pointed something out as family dynamic.
Yeah.
I think that's a biggie is so if you do have so like if I have my three boys listed after Lindsay as a POA, like make sure that they realize, hey, all three of you guys are listed as the second in line,
Mhm.
and I don't know. I mean, I think for everybody it's going to be a little bit different, but for some families I could see that potentially causing some issues, let's just
Yeah,
say. It depends
it
on family
really
dynamics.
is very dependent on how everyone acts within one another. And some people are a better choice because they're more rational. Some people are very emotional and won't be a good person for that role. But it just depends on your individual family.
Okay. All right. So let's talk about I mean, we've kind of talked about some mistakes throughout this conversation, but let's highlight any other ones. And then we'll talk about kind of next steps after you create before we open up to questions. Next steps after you create your trust, just to say. So a biggie that I think a lot of folks need to start thinking about is digital assets.
Hmm.
And if they have, you have your normal investment portfolio that's owned by the trust, but if you have cryptocurrency, for example, which is becoming more mainstream, it seems like,
Hmm.
you know, you should have a plan for that. I'm assuming is because I don't know if these places where you hold cryptocurrency actually allow you to designate the trust as the beneficiary, but that seems like one that people should start thinking about.
Yeah, I think this is a really difficult one because part of the ethos of crypto is self-control, meaning you have the ability to control your own assets with no third party getting involved. And that is a big advantage to people who do. So let's just use Bitcoin as the easiest one. Some people might hold Bitcoin on an exchange like Coinbase or Kraken or something like that. And there are mechanisms through there where if you do pass away, that can be, gifted to your beneficiaries like a typical bank account can. The
Okay.
problem that we run into sometimes is that some people will be holding their Bitcoin in something called a cold storage. This is where you basically own and control your Bitcoin by yourself with no third party whatsoever. The downsides to this would be if you don't give proper instructions to people, we're never going to find it. We're never going to get
Mm,
to it. And we had a probate where we were trying to get access to somebody's, we had a young guy who passed away, trying to get access to his computer, and we still have not been able to yet. And we think that there's instructions on there for his Bitcoin, but we don't know how much there is, if there's any at all. And so
wow.
it's important to have a little bit of disclosure in this regard. But again, kind of the benefit of having it is that you don't have to tell
Yeah,
anybody.
you don't
There
have
is no
to.
paper trail
Right.
like a typical bank would. I mean, there's
Yeah.
obviously a paper trail because it's a public ledger, but it does become a little bit difficult and I wouldn't say a planning nightmare, but it's a lot of
Hmm.
logistics go into it.
Interesting. Okay. All right. And what other ones on here? So like not naming contingent beneficiaries if you have a primary, either name your trust as the contingent or name somebody else as a contingent beneficiary. But absolutely every, another action item on here is going to be if for those that are still working, you have a 401k account with your employer, make sure that you have your spouse or somebody listed as your primary beneficiary. But I see most 401k accounts that I look at with my clients don't have a contingent beneficiary listed. So double
I
check your 401k account.
Yeah, let me jump in on that too, where all too often there's not even a primary. There's been
Yeah,
so
that's
many
true.
times where people have gone from one 401k to another,
Oh yeah.
rolled it over from a different company or got bought out or whatever it might be, and there is zero beneficiary, which means we have to go to court to get access to those funds because it's not going to be in the trust or title to the trust. So it's important to make sure you know your primary and know that there's a contingent, but primary is most important for sure.
Even
Having
if the balance, even if it's like 5 grand, you still have to jump through those hoops. Doesn't
I
matter the
mean, we would still be able to use a small estate affidavit in theory for that, which is basically under 200,000
okay.
in value. But at the same time, we just don't want to have to go. It's a nightmare that they put us through these companies. So
Yeah.
and they
Yeah,
don't.
that is a good one.
So we just want to make sure everything has a pathway towards somebody and
Yeah.
isn't just going to be some rogue account that we have to work on later on.
Oh yeah. Yeah, like roll over your 401k after you leave an employer. Make sure you roll it over to consolidate, it's cohesive investment management. Obviously the beneficiary thing, that's a biggie as well. Um, so beneficiaries, medical decisions, making sure you review that. I didn't even think about that. That's interesting that even the hospital, for example, if it's, 7 years old, your healthcare directives, they may say, hey, this is too old. We're not going to act on this, or this is not valid. That happens.
It's they might, out of an abundance of caution, not accept the documents. I don't
Hmm.
know how likely that would be, but I think other scenarios might come into play where maybe you have a parent in a hospital and you have a document that's kind of old, and people say one of the other kids comes in and says, "Oh, that was already changed. That's not their current wishes." And then the hospital, out of an abundance of caution, might say, "Okay, we're not going to accept anything until we see a new document." So it really depends on the situation, but I think out of
Okay.
just making sure be on the safe side, every 3 to 5 years is a good idea.
All right. I would say another one is because if you have, so let's say um, you have life insurance, right? So
Mhm.
you have life insurance, you name your spouse as the beneficiary, and hopefully you name the trust as the contingent, especially if you have minor children. That's a
Mhm.
biggie. Um, but the life insurance, if you have a couple $1 million of life insurance, which if you have young children, you should have a lot of term life insurance. Which we should talk about that too, is guardian for minors. Because especially for the grandkids of clients on the Zoom. But is life insurance proceeds, is making sure that the trust indicates who's going to be responsible. Yes, you have the executor, right? But who's going to be the advisor to those assets? Because if you have a minor child, you don't want an 18-year-old inheriting a couple $1 million of life insurance. So talk a little bit about what you can do in situations like that.
Yeah, so if are in a scenario where maybe you and your spouse both pass away very suddenly and abruptly, and it's a very tragic situation, we still want to make sure that those funds are going to the trust that are going to be for the care of that young child. And in a situation like that, you might have a guardian of the estate and a guardian of the person, where somebody is managing the money like a financially savvy person, but then you're also going to designate a separate person who is looking after the child. Now, it might be the same person, that's fine too, but having someone who
Hmm.
manages money versus, is actually the guardian of the child might be a good idea as a bit of a check and balance if you don't want to give too much control to somebody. Um, but we want to make sure it's structured in a way too. And there are so many different types of structures of trust. It's infinite as to what you can think of. But generally speaking, my kind of favorite recommendation would be a three-tiered structure, which would be one third at college graduation or 21, whichever comes first, one third at 25, one third at 30. And that way, you're not giving too much money all at once. Money can still be accessed before those three qualifiers for health, education, support, or maintenance purposes. But if they want to go on, spring break in Daytona, Florida, can't do that. It has to be a legitimate reason that's detailed within, those four essentially. Or you can specify in your trust, I want 100 grand of their share to go to them when they want to buy a house at any time for a down payment for a property. You can make all kinds of customizations and specializations within your trust that you just don't have the ability to do through probate, nor would you want to, because we don't want to have to go through the court for everything. We want to be able to do this on our own and choose the people that we want.
So what if and maybe this is somebody's was going to be their question, and I'm sorry, but like just thinking through all these different client scenarios, what if I gifted money? Let's say during my lifetime, I gift some money to one kid, but I didn't give a gift to another one. So all of a sudden it becomes out of whack in terms of if, once they inherit my all the assets,
Mhm.
one ends up with more technically speaking because they got a gift during my lifetime.
Yeah.
What do you do about that?
Depends on what you want. That's a typical lawyer answer for you. If say you gave 50,000 to one of the kids for a down payment on a condo, and you want that to be subtracted from their share, or to give 50 off the top to your other child, you could do that. You can specify that one child has the right to occupy your property for 5 years, so they can live rent free, catch up, maybe save some money. You could say one has the right of first refusal for property. All these different customizations really go into your trust. And that's where collaboration is really important with an attorney who can help you with the language, who can help you with the options. Um, a lot of what we can't do would be anything that is violation of public policy. So we can't say
Hmm.
you have to vote Democrat or Republican or something like that. That we get that
Hmm.
question all the time. But you can't do something like that. But your standard incentives you can definitely do. Like don't be on drugs, don't be, like drugs or alcohol are a big clause that we have in all of our documents, or go to college and you can get a share at some point. A lot of people want to have a very common thing nowadays would be, I want to make sure that my kids never sell the house, right?
Hmm.
Can't really do that. That's not something that we can do unless because trust can't go on in perpetuity. That's a rule for California. It can only be around for 90 years. So you can limit what they can do.
Hmm.
You can limit how long before they can sell the property, but you can't say that they can never sell the property because you wouldn't want your trust to be around for that long too. Because remember, there are administrative costs to having a trust open for a certain amount of time as well too. So there's definitely downsides to it, but you can customize a trust to be basically whatever you want it to be within legal reason, I guess.
Okay. All right. Let's see. So next steps, we kind of have been talking about this throughout, but next steps after you create your trust, and this is, I can't emphasize this enough because people think that once they sign and get the notary done and they've got this pretty nice binder, that they're all set, but they're really not because you have to go to your financial institution. I know for us, like, when you get a trust, we have to open a new account and transfer the assets into the trust and close that old account. You have to update beneficiaries on your retirement accounts. You need to, store a copy of it. Make sure you have that thing on a thumb drive. I know
Mhm.
for me, a lot of estate documents are stored in our financial planning portal within eMoney. So it's like a collaborative storage center where, somebody uploads a document, I have immediate access, viewing access, and downloadable access to it. So it's good to have a digital copy there. Share it with your family members if you're comfortable doing that. But anything else that you can say there? And then while Justin chimes in on that, I'm going to open the chat because that was the last kind of structured slide. But I'll open the chat, the Q&A, so you can type in your question, or if you prefer, if you want me to unmute you, I can just unmute you and you can ask your question live.
Yeah, so I think to answer that, Joe, the most important thing is making sure your trust is funded. Your trust can't really do anything if it doesn't have assets underneath it. So, an open entity trust like that might have your wishes as to what's going to happen, but unless there's something under the trust itself, under the control of the trust really can't do anything. So, we go over this with our clients, making sure they understand how to transfer their bank accounts and their retirement accounts as a contingent beneficiary. But we're also here just to make sure that if there are questions, they can always call us. But making sure your assets are protected by the trust is definitely the most important thing once the trust is signed and completed.
Okay. And yeah, make sure you have a digital copy of it stored with your advisor
Yeah,
if you have an advisor.
absolutely. Flash drive, we have a copy of all of our clients. Well, since the technology became readily available about 7 or 8 years ago, we have a scan of all of our client documents and we give everyone a flash drive as well too.
Ooh, that's a good one. So amending.
Yeah. So amending a trust is kind of a difficult thing depending on the situation. So most estate planning attorneys are a little hesitant to amend somebody else's trust. The reason being is I don't want to implicitly ratify their work. If there was ever a lawsuit on the underlying operating trust itself, and like maybe there's nothing wrong with my amendment, but ultimately I still get brought in on a lawsuit for maybe some kind of malpractice claim on the original trust. My insurance is a little bit, hesitant about this. They don't really like us doing amendments to other trust work done by other attorneys. There are situations where we might, but usually we want to kind of revamp the trust ourselves and make sure that our documents are cohesive and clear all the way through.
Okay. All right, that's good to
But
know. So
you're welcome to always go to a different trust attorney if yours retires, or even if they don't retire and you don't like your attorney, you're not stuck with that person.
so would you be able to review somebody's trust and say you're good, like you don't need to do anything?
Yeah. Oh, that happens all the time. Yeah.
Okay. All right. Um, oh yeah. So I mean, this is pretty relevant, is people leaving California. Um, can you take your trust with you to other
Oh yeah.
states? Is it still? So California's estate laws are so rigid that a California trust is basically valid in any other state.
Well, it depends on the person's trust. I can only
Yeah.
speak for mine. I have seen trusts that won't work anywhere because they were so bad. But our
Okay.
trusts, if we've had so many people move out of California and their trust is still fine, it goes with you wherever you go. You don't necessarily need to change it. It's not a bad idea to say I'm now a resident of, Flagstaff, Arizona, or whatever, wherever you might have moved. But you don't have to change the whole document, no matter what any other estate planning attorney out there says, your trust will still be good if it's our
Okay.
trust.
All right. I'm trying to think of client cases that is just relevant to life, because life happens. Oh, spouse passes away. Oh, yeah. So I'm thinking about like your seminars. So
Yeah.
Justin, for everybody on here, Justin does seminars around San Diego County and does a really good job of educating people on trust. And I know you have done the analogy of marrying Macho Man in
Yeah.
your trust. And I know people on here don't know what we're talking about, but talk a
Yeah.
little bit about that. If you have a divorce situation, what you ought divorce or even death,
Well,
one spouse passes away.
yeah, in our seminar, we talk about Macho Man marrying in at that point with, Jack and Jill. Jack had passed away, and this is a joint tenancy example where a lot of people think that a joint tenant situation for your property
Oh, okay.
is a
That's right.
sufficient way of planning your estate, and it's really not, just because ultimately joint tenancy just doesn't have a long-term avoidance of probate. It's a temporary avoidance where if one person passes away in a married couple, the survivor gets the property. But at that point, the if Macho Man swoops in and gets added onto the property, then Jack and Jill or yeah, Jack and Jill or whatever the scenario we use,
Yeah.
their child doesn't get anything and Macho can inherit everything. Whereas if you have a trust, it's a little bit different. Um, a trust, where you can have different provisions of the trust if it goes to the child upon passing. But if one person passes away, the survivor can't usually add on another person in the trust who can change the trust. They can get remarried, but they don't add that person onto the trust usually.
Okay.
So there should be protections in place, and you also have to trust your spouse and whatnot to not do something like that where they would disinherit kids, whether it be purposely or unintentionally.
Got it. Um, waiver trust needs to be updated, so we have to create a new trust instead of just updating it. Depends on the trust, I guess.
Yeah, it depends on the changes as well too. Often
Yeah.
changes will be like bank accounts or cars or things like that, and usually you can update that with your schedule of assets. But it's not every scenario where it has to be completely redone or revamped. If it does need to be revamped, which these very old trusts need to be because they have outdated language, especially AB language. Um, for a married trust where there was kind of like this mandatory division of assets upon one person passing away. That was very, very common back in the day. Usually we want to update that, but even if we did revamp a trust, we wouldn't revoke and start a brand new one. We just revamp the old one, which makes it like the second addition to the trust. So you don't have to go retitle all of your assets. Everything stays under your original trust name and date. It's just we're just kind of changing the language on the inside.
Okay. All right. Um, yeah, so next steps, as we kind of highlighted, like contact your financial institution if you've just created it. Make sure you understand clearly what steps you need to take with the bank and your investment institution.
Mhm.
Um, double check your beneficiary structure on your retirement accounts. Do you need to name the trust as the contingent beneficiary or not? That's going to usually be dependent on your specific situation. Um, you would store a digital copy somewhere. So thumb drive, not just a thumb drive, but I would say somewhere in a cloud so that it's accessible from anywhere.
Mhm.
Um, reach out to, so if you've named whoever your successors are or the executors, make sure they are clear that that they've been hired, if you will, to be your successor or the executor.
Mhm.
Guardians, so like if you have that tragic situation with minors, is making sure that everyone's on the same page. Like if I think about it, if something, God forbid, something happened to Lindsay and I, who in the heck is going to want to take care of three little boys? My
Yeah.
my kid, that's a huge undertaking.
And
So
there involves a bit of work outside of the trust as well, too. If I can just kind of give a personal recommendation, you might have a situation where you create the estate plan and it's very formal as to, okay, here's my successor trustee who's managing the money for the kids. Here's who's looking after the kids. And then on the side, you might want to have written instructions. Hey, this child has T-ball, is good friends with this person, and likes this kind of food. Or you can get very specific about your kids and give the details that only you might know and what would work best for your guardians as well. So the more you can, I guess, communicate and divulge and disclose, the better off everyone's going to be. There's nothing
yeah, so
wrong with more
communication.
disclosure. Yeah.
Yeah, so open lines of communication.
Yeah.
All right. So we'll wrap up a little bit early, but before we do, looking ahead,
There's one
any
more
big
question there, Joe.
changes? Yeah, I
Yeah.
know. Any big legal changes that you see coming up? Unless there's any
Uh,
other questions.
Okay, so there were a couple of there's a change that happened a few years ago. Prop 19 was an undercut to Prop 13. Essentially, what that means is that you used to be able to transfer all of your properties to your kids without any tax reassessment on the property
It's
tax.
like real estate.
Yeah, and now the new rule is you can only transfer one property. Everything else is going to get reassessed no matter what you try and do. That's the case. Um, there is a little bit of a change to the estate tax, more commonly known as the death tax. The estate tax or death tax is on estates right now worth more than 13.99 million per person. The estate tax is going to go up to 15 million with the new what was it called? The Big Beautiful Bill.
Yeah,
Uh,
one big beautiful bill.
that's going to increase to 15, and I think it's going to adjust annually for inflation. Quite simply, and I think quite publicly, no political statement needed here. The Democrats want it lower, the Republicans want it higher. That's just the way they've been fighting over the estate tax for a long time. Luckily, in California, we do not have an inheritance tax and we don't have an
Shockingly.
estate tax, very shockingly. But inheritance tax is kind of rare. There's only, I think, 5 states that actually have an inheritance tax. So most likely, if you
Hmm.
pass away and your estate is worth less than 15 million, there will be no tax to speak of, except for a property, a rental property would get reassessed if that were the case. Very situational, of course, though, and no capital gains tax is such a bonus as well. But I don't know of any new changes that are coming up that are really going to affect a lot of trusts, other than the 15 million estate tax.
Exemption.
If anything does come up, I usually try and make an article or write an article, share it with Joe if I can too for his newsletter base, or we post it on our social media. If it's something that's going to affect, a lot of people, not just the uber rich. So,
All right. Good to know. All right. So in terms of contact, how you can reach us, how you reach Justin, Justin at Lawyer Blue Jeans. He's here in San Diego. He's down in Old Town. So go get your trust checked and go get yourself a burrito in Old Town after you get it done. But that's our contact information. Anything else you want to add, Justin, before we sign off?
yeah, give us a call anytime. Send me an email. I'm very responsive to emails. This is all I do, usually every morning. Since we're not an hourly firm, we're a flat fee firm. We have this kind of open dialogue with our clients, and if it's kind of an ongoing relationship where you don't have to worry about getting charged every time you talk to us, like you do with most attorneys who charge by the hour. We like to be here to make sure your questions are answered. So. You'll see us, our presence out in the community. We have seminars this week, actually, tonight in El Cajon, tomorrow's in Carlsbad, Bonita on Thursday, Mission Valley on Saturday at noon. So we're kind of all over the place, and it's we're
Hmm.
happy to help if anyone has any questions.
If you need to get a trust, cost, what should, generally speaking, what is somebody going to be paying for a solid trust to be completed?
I mean, if someone's quoting you like 7, 8K, that's a little too much, I think. If someone's quoting you, 1,000 or 1,500, that's also a little too low. That kind of makes me
Hmm.
nervous. And I've
Okay.
seen a lot of those trusts where they just weren't done by someone who knows what they're doing, or like a paralegal has created those trusts. I've seen a lot of those in probate too, and that's what you want to avoid. Luckily, and I will do a little bit of bragging, we have not had one trust miss in the 25 years that we've been doing trusts. And so, your typical trust is going to cost you anywhere from 2 to 4,000, depending on the complexity of the plan. Your
Okay.
more
Reasonable.
advanced planning is going to definitely cost a little bit more, but those are for the
Hmm.
estates that have a lot more to lose as well. But your basic trust, should be right in that range.
Got it. Okay. Cool. All right. Well, everyone, thanks for joining the webinar. I hope you found this helpful. I hope you took away at least maybe one or two action items. And if you have any questions that you still do want to bounce off of us, by all means, please don't hesitate to reach out. Happy to help in any way. But Justin, thanks for joining me in this webinar. Maybe we'll do it again and talk about something
Yeah,
else. I mean, it's fun having these conversations. It's nice to provide the education to the community.
absolutely. Well, thank you for having me. And yeah, if anyone has any questions, please just let me know.
All right. Take care.
All right.
See
See
ya.
you, Joe.